Justin, if you're looking to buy or sell a business, last time we talked about some of the employment considerations that, I would look into on behalf of a client. What are some intellectual property considerations that you may help a client with during that process?
So we're going to hit these pretty fast, but for most companies that are developing some kind of product, there are some special considerations. One would be making sure you've got your founder's assignments. So anybody who's a founder of the company should be assigning things into the company that they develop. And that's both looking back and looking forward. So because a lot of times founders get started before they form the company, and you want to make sure that's contributed. Then you want to look at non-competes for your founders, because once they have a breakup, you want to make sure people are locked up, that you're not going to have some internal problems there. Then you want to look at anybody who's not an employee that's assisting. You want to have a written agreement with them, and you want to have either an assignment or you've at least handled intellectual property in those agreements. Usually it's going to be an assignment of intellectual property to your company, or if you're buying, to the company you're buying. And you just line up all the people, right? The names of their people, and make sure they have an agreement with it. Then for employees, same deal. You want to make sure you know which employees are working on projects, which ones are working on intellectual things that'll develop intellectual property, and then make sure that you've got policies in place or agreements in place to transfer everything. And usually employees will be required to sign an inventions and an intellectual property agreement for this purpose. So making sure that's in place. Then your basic blocking and tackling, things like filed a trademark. Have you actually secured your trademark? Or has the company trying to buy secured it? Because if not, do you know if you can continue to use it? What's that going to cost you? Are there other companies out there? And then at least have considered whether patent is applicable. Many companies it's not, but just having that discussion with somebody, figuring out, okay, is this something that applies to my company? If not, you just put it behind you, and when it comes up as you're selling the company, you have that discussion. Like, we talked about it, decided not to do it, whatever. Or if it does apply and you decide to go forward, then you figure out how to prepare that application and file it. And then the last thing I would say is most companies like having a policy and procedures in place to protect their trade secrets. So to make sure you know what those trade secrets are and that you're doing something to protect those. These are all things that buyers are going to come and look at you. They're going to look at the company and figure out everything you've done. And if you're not doing them, then you're going to have to figure out a way to fix that at that point. So it's much easier to do on the front end. And if you're buying a company and you show up and they don't have any of this stuff, that's a red flag. So that's why it almost doesn't matter which side you're on.